Hello, everyone. Welcome to the American Diabetes Association's Fighting for Fairness webinar series. Today's session is on the rights of people with diabetes in public accommodations. We want to thank the Skadden Foundation for sponsorship of our program today. A few housekeeping notes before we begin. If you want to earn CLE for this webinar, please listen to the following instructions. At 2 points during the webinar, I will share a code that you will need to put into the attendance and evaluation form at the end of the webinar. That link for you to do so will be available at the end of the webinar, and we will give you a couple minutes to complete it. While the American Diabetes Association attempts to ensure that all information is accurate and current, this general information about potential legal protections and medical best practices is not a substitute for individualized legal or other expert advice and assistance. The American Diabetes Association, its staff, and its volunteers do not provide legal or medical advice or represent you. For detailed legal advice or representation, contact to consult an independent attorney, and for healthcare consultation and advice, consult with your professional healthcare provider. Final note, we will leave time at the end for Q&A, so please put your questions in the chat as we go through the presentation, and we'll do our best to answer all of them at the end. I will now pass it to our speakers, Dr. Brittany Bruggeman, Assistant Professor of Pediatric Endocrinology at the University of Florida, and Anthony May, Partner at Brown, Goldstein, and Levy.
All right. Hello, everyone. Thank you for joining. I'm excited to talk to a virtual room full of lawyers. Not my typical audience, but this will be fun. So I'm just going to give a background on diabetes because I think to understand the needs of people with diabetes, you really need to understand what it is and how we treat it. So if any of you have diabetes, apologies, this will definitely be a review for you. But for those of us who don't, we'll just go through things. So this is a little bit of a surprising statistic to some people, but 1 in 10 Americans has diabetes today. So it is very prevalent, very common, and something that you will run into. Someone in your life has diabetes. There's a lot of stigma involved with diabetes, which we won't get into too much today, but that may be why you don't know everyone who has diabetes in your life. But there are quite a few people with it. And so many people do wonder what their rights are. Places like theaters, stadiums, courthouses, airport security, and more. So what is diabetes? Diabetes is actually a group of diseases that are characterized by high blood glucose. And glucose is a medical term for sugar. So it's high amounts of sugar in the blood, which is also called hyperglycemia. This is caused either by a deficiency of a hormone called insulin, or insulin is not working as well as it's supposed to be. So I have this little diagram on the right showing insulin as keys. And so when you eat a meal with carbohydrates in it, your stomach will digest the meal, and then your intestines will absorb the sugar. But in order for the sugar to get from the bloodstream into the rest of your cells to be used as energy, you have this hormone called insulin that helps your cells to know that it should take up sugar and that there's a lot of sugar around right now, so you should go ahead and take it up and use it. And so insulin is kind of like a key for a house, and the house is the cell. And so insulin will allow the cell to take up sugar. In diabetes, there either isn't enough insulin around, and so the cells don't know that they're supposed to be taking up sugar, and so it just gets stuck in the bloodstream. Or insulin, there's a lot of insulin around, but the key just doesn't quite fit correctly, and it doesn't work properly. And so those are kind of type 1 and type 2 diabetes, which we'll get into a little bit more. So type 1 diabetes, 1 in 20 people with diabetes have type 1. So it is less common, but it is still quite frequent. 1 in 300 people overall have type 1 diabetes. So my high school graduating class was about 300 people. So, about one person in my high school graduating class had type 1. Most people are children or teens at diagnosis, but almost half are adults at diagnosis because you can get it in adulthood. Yeah, there we go. You can get it in adulthood. And since adulthood lasts a very long time, the age of 18 all the way up, there are quite a few people who get diagnosed as adults. But so it really spans the whole age range. So I've had a patient who we diagnosed with type 1 at 9 months old. So you can get it as a very young baby, or, as like a 60-year-old, you could get type 1 diabetes. You don't have it at birth, though. It's not a genetic disorder that's present at birth, but you do have genes that are risk factors. And the genes are typically risk factors for autoimmune diseases, because type 1 diabetes is an autoimmune disease. And so the immune system gets confused. It still works well to attack viruses and bacteria, but it actually kind of works a little too much, actually, and it attacks the cells that make insulin. And those are located in the pancreas. So the immune system, specifically T cells, get confused, attack the cells that make insulin, and so then your body can no longer make insulin. And so we always have to treat type 1 diabetes with insulin. And insulin is very important. So even if you go a couple of hours without insulin, if you have type 1 diabetes, you can get into very dangerous health conditions. So people need continued access to insulin with this disorder. Some symptoms of type 1 diabetes: because your body can't use glucose as fuel, you burn fat. And so weight loss is a component of before diagnosis of type 1 diabetes. Loss of energy, increased thirst, and frequent urination are because the glucose is stuck in your blood and can't get out any other way other than peeing it out. And so, the glucose gets filtered through the kidneys, from the blood through the kidneys and out into the urine. And it pulls water along with it. And so you end up peeing a lot. So, it could be multiple times a day. My co-fellow had that type 1 diabetes, and she said when she was first diagnosed, she, on like a 30-minute trip to school, was having to pull over and go to a gas station like twice. So it was bad right before she got diagnosed. And because of that, you get dehydrated and have increased thirst. And so you can get very dehydrated, and then you can develop something called diabetic ketoacidosis, which is an emergency condition that often requires admission to the ICU. And that is where your body builds up byproducts of burning fat, and they're called ketones. And because you have no insulin present, you get very high levels of these byproducts called ketones, and they're acidic. And your body does not like having acid, basically, in the bloodstream. So it causes all sorts of issues. And then you're also dehydrated because of the frequent urination. And so, you can get very sick, vomiting, dehydration, and it, rarely, luckily, but it can lead to coma and death. And, it's a small percentage of people, like 2 to 3%, but it's still high enough that we want to avoid this. And then symptoms of type 1 usually start suddenly. The older you are, the more gradual it can be at onset, but usually within a matter of months, you'll notice symptoms to diagnosis. Type 2 diabetes. So most people with diabetes have type 2. And this is where you have insulin in your body, at least initially. You have actually too much kind of insulin around because it doesn't work well. So you have something called insulin resistance, where the cells do not process insulin correctly. Most people are over age 40 when diagnosed, but it is becoming more common in younger adults, teens, and children. So I would say you could get it as young as 8 or 9, but typically not like babies or anything like that. It is more common in people with a higher BMI in the overweight or obese categories, because having fat deposits in the liver and the pancreas leads to insulin resistance, where insulin can't work as well. Also, people with low SES or racial and ethnic minorities. And there's a whole myriad of hypotheses for why that is the case, but there's some related to stress and the effects of cortisol. So, high cortisol leads to insulin resistance. So that could be it. There could also be less access to healthy foods, less access to physical activity, and things like that. And then if you have a family history of type 2, so you're more prone to getting insulin resistance, you are much, much, much more likely to get type 2 diabetes. Those symptoms are similar, but they're a lot more subtle typically. And sometimes you can have no symptoms at all and still have type 2 diabetes. But when you do develop symptoms, they are similar to those of type 1, just more gradual and less pronounced typically. But they may be mistaken for other situations or problems. And so 1 in 4 people with type 2 actually are not aware that they have it. So if you haven't had your blood sugar tested and you're over the age of 40, for sure you should go get tested just to make sure. It can go undiagnosed for many years, and you may need insulin. So even though insulin doesn't work as well, giving more insulin kind of pushes the system to work. So you may need insulin. And then eventually, because blood sugars are high, people do actually develop insulin deficiency eventually because the cells that make insulin get stressed and stop working as well. And so those people also need insulin, or you could use other medications to help insulin work better. So that's like metformin that you've heard of. Ozempic is a popular thing to, that we talk about a lot recently, but that category, so GLP-1 agonists, that category works very well to treat type 2. So you may be on those medications and also maybe on insulin or maybe not. Diabetes is important to treat properly because if you have high blood sugars for a prolonged period of time, there are a lot of risks for serious health problems. So heart disease is the #1 killer of people with diabetes, stroke, kidney failure, blindness, and amputation. And these are all related to blood vessel problems that develop in relation to glucose. Basically, when there's high levels of it, can bind to the blood vessel walls and cause issues. And then there's also other related things that kind of come downstream from that. So how is it treated? So type 1 diabetes requires a lot of effort on the part of the patient. So they have to monitor their blood sugar a minimum of 6 times a day, but really now the standard is more like all the time. So we've really moved to continuous glucose monitors as more the standard of care, and those measure your blood sugar basically every few minutes. They always need insulin. And that's not just like 1 shot a day. They need either multiple injections a day every time they eat carbohydrates, or something called an insulin pump, which I'll show you pictures of. They need access to treatment for low blood sugar because we are not a pancreas or beta cells, unfortunately, and we are not quite as good at matching up food intake and activity and all the hormones with correct blood sugar control. And so low blood sugars do develop quite frequently. And so there's a medicine called glucagon to treat those, and then fast-acting sugar and snacks. People need education on how to manage their diabetes. Healthy food choices do help with management of type 1, and then physical activity as well. For type 2, they always have to monitor their blood sugars, either with continuous glucose monitors or the finger stick blood sugars that you know about. Again, education, healthy eating, physical activity, and like we mentioned, medications, which could include insulin, and also need treatment for low blood sugars. So like I mentioned, for glucose monitoring, there's the typical blood glucose meter that you guys have probably seen. And you basically poke your finger with a little thing called a lancet, get a drop of blood, put it onto a test strip that's connected to the meter, and it tells you what your blood sugar is. More recently, CGM has become more of the standard of care, and that is a device that's inserted just under the skin. So there's like a little tiny, I guess it's not exactly a catheter, but a little piece of plastic basically that goes just under the skin and measures glucose every 1 to 5 minutes. And then it Bluetooths to your phone, which is really great. So you can see your blood sugar readings. That's what the phone picture at the bottom is. It's showing this person what their blood sugar is right now. The arrow shows you trends. So whether it's kind of a flat line or whether your blood sugar is going up or down. And it also can go to caregivers. So you can have, a child who has an app on their phone, and then also their parents can have a different app that receives the child's blood sugars, which is really great. So this is a picture of a little boy who's wearing a continuous glucose monitor. That is the one that I have circled. And then the other device that he's wearing is an insulin pump. So we do not yet have a device that both measures your blood sugars and gives you insulin in one piece. So people have to wear two different pieces. But that's what both of those things are doing. And people get confused. So the continuous glucose monitor does not give insulin. It just monitors your blood sugar. So to give insulin, people with type 1 and 25% of people with type 2 have to give themselves insulin. And you can either give it with a vial and a syringe, so you just draw it up and give it that way, with a pen, or with a pump, like I mentioned. So there's insulin inside of those two devices at the bottom. And you can tell the pump how many carbs you're eating, and then the pump has the doses programmed into it, and will give you a certain number of units of insulin depending on how many carbs you ate and then what your blood sugar is doing. And then most recently, there's automated insulin delivery systems that can actually, the continuous glucose monitor communicates with the pump, and the pump can give you more or less insulin depending on what your blood sugar is doing. So these are pictures of people wearing different pumps. They're both tandem pumps, and the one on the left is basically the Control IQ, T-Slim Control IQ, which is a traditional pump that has a catheter and a pump site that is inserted just under the skin. The insulin goes through that tubing that you see, and it comes from the pump. The one on the right is the newer version they have called the Mobi. And it's basically just the pump is attached, it's like taped almost to your skin, has a very short catheter, and it goes directly into the skin through there. And then the other ones that I showed you on the previous little boy, that was called an Omnipod. And that is basically the pump itself is inserted directly onto the skin. And then they have either an app on their phone that communicates with the pump and you can dose through it, or they have a separate device that communicates with the pump. So to treat hypoglycemia, like I mentioned, it happens pretty frequently. Symptoms are confusion and combativeness. So this can become a problem when people have interactions with law enforcement, because law enforcement can think that they are being purposefully combative, but people may just have a low blood sugar and they don't realize it. And then if they don't treat it, it can be very dangerous. So you can have seizures, brain damage, and even death from low blood sugars. So, and it's very quick. It can develop within minutes. You need to either have like glucose tabs or juice. So if you're conscious, you can treat it with that. Or if someone becomes unconscious, they basically look like EpiPens, but they have a medicine called glucagon in them, and you can inject the glucagon, or there's a nose spray that you can use. And then hyperglycemia, we already kind of went through the symptoms of hyperglycemia. It does develop more gradually, but if you don't give insulin, for even hours, you can have these symptoms and get into a very dangerous situation as well. All right, and then I will hand it over to Anthony.
Great. Before we move on to the second half, I just want to give everyone the first code. The first code is 3488.
Great. Thanks, Jen. And thanks, Dr. Bruggeman, for that great overview. Hi, everybody. My name is Anthony May. I'm an attorney at Brown, Goldstein, and Levy, and we're based out of the Baltimore, Washington, D.C. region. I'm thrilled to be here today, and we'll share that as a person living with type 1 diabetes. I'm going up on my 10-year anniversary. Found out right after I graduated law school, so I like to joke that law school gave me diabetes, which was great. But I'm very happy to be here presenting today. Our firm does a number of civil rights litigation across the country, but a lot with respect to persons with disabilities and advocating for persons with disabilities in a variety of contexts, including some of the contexts that we're going to talk about a little bit today under Title III and public accommodations. So with that, we're going to give you a very high level overview today of what laws govern public accommodations, and then we're going to talk a little bit about some scenarios that Dr. Bruggeman and I are going to be able to talk about the legal and medical perspective about. So when we're talking about places of public accommodations and what it means to be a person with disabilities, we are talking about the Americans with Disabilities Act, and specifically Title III. So as a very high level overview, Title I of the Americans with Disabilities Act covers employment. Title II covers access to state and local government services. Title III is places of public accommodations, and Title IV governs telecommunications. And so what do we mean when we talk about places of public accommodations? If we can go to the next slide, got a list of a variety of places. And when we talk about public accommodations, it includes businesses such as private entities that are open to the public and are generally provide some sort of goods or services. So there are a number of different examples that you can see here. I'm going to talk a little bit about some cases that cover some of these areas in just a little bit. And then we'll go to the next slide, but it also includes not just those places, but also public accommodations that are provided through programs, activities, or services that are run by government entities. So a little bit of overlap with Title II there. So you can see all of those examples on your screen right now as well. A couple things I want to mention when we're talking about the laws that govern, and we're talking specifically about Title III. If you're an attorney and you're thinking about bringing a case under Title III, there's always that pesky thing called standing that you've got to consider, and whether an individual has standing to bring a suit. And while there are generally nuances across the country, most often I would say that it is not simply enough to say that you are a person who wants to go somewhere, or who wants to go to a concert, or who has an interest in going to a concert, or has been someplace one time but has no intention on going back. In those instances, again, with some nuances across the board, it's often that a court will find that, well, while we understand that something happened, you don't really have standing to bring a claim because you haven't shown that you're going to return to this place or that you're going to frequently access. So that's just something a litigation tip to kind of keep in mind. But obviously, you're going to want to research what your jurisdiction you're in and what standing requirements are in that specific jurisdiction. And so we'll switch to the next slide. And so let's talk about the ADA regulatory text. So with most statutes, most federal statutes, it permits it permits the ability to create regulatory text to interpret what the law is and govern what the law is. So adopt implementing regulations. And the ADA's regulatory text is really, really critical because it provides very specific definitions and very specific nuances into each title of the ADA, what is required. And we're going to talk a little bit about those in just a few moments. But in addition to the Code of Federal Regulations, you'll often see guidance from various administrative bodies. So for example, the EEOC, DOJ will often issue guidance to apply the ADA under certain circumstances. So one that recently comes to mind is under the Biden administration. There was governance under the ADA and specifically under Title I, and how the use of artificial intelligence may or may not run afoul of the ADA in certain circumstances. So that's just kind of one example. So there's often guidelines out there that has since been rescinded, but is still available. And those guidelines often, while not controlling or have any sort of legal import in terms of whether it must be followed, it can provide really good examples for scenarios that you're looking into whether or not there's a potential violation of the ADA. So those guidance can be really helpful. So let's look at some of the key regulatory texts of Title III of the ADA. And so we've got two definitions here. 28 CFR 36201 essentially applies a broad definition of what is required for a public entity, and that a public entity shall not essentially deny somebody the full and equal enjoyment of the goods, services, facilities, privileges, advantages, or accommodations that a place has. And I think that language is so critical to keep in mind, that the objective is equal enjoyment. Doesn't mean somewhat similar enjoyment, doesn't mean, well, you can get these benefits, but not these. It requires equal enjoyment. And how do you achieve that if you are a person with a disability who cannot access those services, facilities, privileges based on your disability? Well, and oftentimes places of public accommodations are required to provide reasonable modifications to their policies or practices or procedures. So if those policies, practices, or procedures result in the exclusion your inability to participate in those programs based on your disability, then that would run afoul of the ADA. And I think here I want to talk a little bit too about when we're talking under Title III, what specific remedies are available under Title III of the ADA. And under Title III, unlike Title I and Title II, the main remedies a person can get are injunctive or non-monetary relief. That is requiring an entity to either modify its policies or create some sort of ability to provide somebody with an opportunity to request and obtain modifications to the way their program is administered so that they can equally access it. And one thing that I always point out, again, kind of a litigation tip to think about if you're litigating cases under Title III, training is something that I always think of. And whether that's in some sort of settlement process or whether that's in a consent decree, getting adequate training. So if you get a policy in place, if you get a court or a jury or somebody to decide that a place of public accommodation has violated Title III of the ADA, you want to first and foremost get them to adopt a policy that remediates that, but also make sure that everybody who works there, employees, are properly trained to know why those what those policy changes are so that they can adequately adhere to the ADA. The other thing that you can get under Title III of the ADA is attorney's fees. And so for those who often practice under fee shifting statutes, the ADA is a fee shifting statute, meaning that traditionally the American rule is that all parties kind of incur their own costs. But with some statutes like the ADA, if you are the prevailing party, meaning you have won and gotten some sort of relief, you are then entitled to fees. And those are obviously reasonable fees based on the jurisdiction that you're in. So that's generally the kind of two main definitions for what we're looking at when what is required of a place of public accommodation. But let's talk a little bit about the exceptions to that rule. So if we go to the next slide, there are certain technical regulatory exceptions to Title III of the ADA. And I will point out that there's some really good there's a technical assistance manual available online that provides real specific examples of kind of what these exceptions are. But the two main ones we're talking about under Title III are direct threat and fundamental alteration. And also just note that private membership clubs and religious organizations are not covered under Title III. So those generally are the categories of what you would commonly think are public places of public accommodation, but are accepted from that. But then even for those places that are covered, they are not required to provide any sort of reasonable accommodations if doing so would result in a direct threat or would result in a fundamental alteration of that service or program. So what do we mean by that? So a direct threat, as you can imagine, is a significant risk to the health or safety of others that cannot be eliminated. So if there's some sort of manifestation of your disability that would pose a significant safety risk and can't for some way be mitigated, then a defendant can argue as an affirmative defense that they cannot be required to adhere to the ADA. Fundamental alteration is something that you see across essentially all of the titles of the ADA. And that is really a change in whatever the service or program that is being offered by the entity. It would be requiring, if providing such an accommodation would require a change that would be so significant that it would essentially alter the nature of the goods or services, then that entity isn't required to do that. And I think under this context, one good example would be, if I go to a restaurant and I demand that the restaurant provides me every food has to have absolutely no sugar in it. That would be an example of a fundamental alteration because the restaurant is within its rights to provide food in the way that it sees fit and doesn't have to prepare special dishes for me as a person with diabetes. So I want to kind of talk about the next slide. We're going to talk about a few cases that I think are just interesting and important to highlight as we think about how the ADA is applied in certain circumstances. And so to give it just a general overview here, a couple of the cases that I want to talk about. So the first is United States versus SFX Entertainment. And so this was a lawsuit that was actually initiated back in 2003, and it was filed by the Department of Justice against one of the largest operators of concert venues in the country. And this concert venue operator had a policy of completely barring individuals with disabilities from having access to their blood glucose sugar monitoring equipment and insulin inside a concert venue. And so while it might seem like 2003 is a long distance away, it's really not that far away. But at the time, and as Dr. Bruggeman pointed out, we didn't really quite have the advanced continuous glucose monitoring systems that we have today that pair with your phone. So these are independent kind of monitors that an individual has to keep with them. And so this defendant in this case had a blanket policy of excluding those. And the DOJ filed suit and said that that runs afoul, that violates the ADA, because you are denying somebody, and as Dr. Bruggeman pointed out, it is so critical and important to be constantly monitoring your sugar. And for those living with type 1 diabetes, I think confusion and anger are things that happen often in my day sometimes. And so without the ability to monitor that, you really are being denied the opportunity to enjoy what the services that those concert venues are providing. And so there was a great settlement reached in that case, where SFX, the defendant, was required to alter its policies to permit individuals, specifically with diabetes, to allow them to bring those materials in with them. And I think settlement order is available online. You can look that up, look up the case, and it's a really robust and great settlement. The second case I want to talk a little bit about is Red River Valley Fair Association. It's a settlement agreement that was again reached, where in this instance, it was an organization that ran fairs across the country, and it barred all sorts of outside food and drink. And the case was essentially initiated by a parent who had a child with type 1 diabetes, and initiated the complaint because it led that the child was required and needed to, in fact, bring in snacks, bring in things to address low blood sugar levels when they occurred. And so that was another case where a settlement was reached, and the defendant there agreed to allow individuals with disabilities to bring in outside food and drink upon request, if you could show that you needed that as an accommodation. I just anecdotally and kind of my personal experience, I've seen this happen actually with TSA lines. And when I bring in juice boxes, they have to test them for explosives, but I'm allowed to bring them in even if they exceed the liquid limit that you're allowed to bring. They are acceptable. So that's kind of a modification that I've seen in real life. The third case I want to talk about is Rendon Valley Crest Productions, and this is not specific to diabetes, but an interesting case nonetheless. And this is a case where there were, we all probably remember the show Who Wants to Be a Millionaire. It might even still be going on. I don't even know if it's still going on today. But this was a case where individuals were able to call into a hotline to register to be a contestant. And in this instance, there were a group of individuals who had kind of a constellation of disabilities. Some were deaf or hard of hearing, and others had kind of disabilities that manifested in mobility issues with their thumbs. And so the only way that these individuals could apply to become a contestant and then travel to the studio to participate was by entering through this phone system. And the phone system was an automated system that didn't provide for any sort of accommodations for people who were deaf, and didn't give enough time for those who had mobility issues to enter their kind of responses into the phone system. And so the defendants filed suit under Title III, or the plaintiffs filed suit under Title III in this case. And the argument there that the defendants raised was, well, Title III only applies to physical places of public accommodation. And this phone system is not a physical place of public accommodation, and it's separate from actually going into the studio. And we would provide you accommodations if you were coming into the studio, but we are not going to provide you accommodations to get access to be able to apply to come into the studio. And what the 11th Circuit found in that case was that actually violates the ADA. That it would violate and the quote I like is, it would violate the ADA for the defendants to screen potential contestants just outside the studio by refusing otherwise qualified persons because they are deaf or suffered from diabetes or HIV. And that's why I bring up HIV or diabetes, because it's specifically mentioned in this case. And it highlights why even sort of methods of administration that could screen people out from getting into those physical places could violate Title III of the ADA. And the final case I want to talk briefly about is Colby versus Endocrine Services. And this was a more recent case out of Colorado. And this case involved a claim under both Title III of the ADA and under a state law analog, so Colorado's anti-discrimination statute. And in this case, the plaintiff was an individual patient who went to get physician services from the defendant, and the defendant employed a single doctor, and the doctor refused to allow the plaintiff to bring a service dog in with them. And so the plaintiff brought suit under again Title III in Colorado's Anti-Discrimination Act, and a jury concluded that by blanketly prohibiting her from bringing in their service animal, that was a violation of Title III of the ADA. And so in this case, because they brought a state law claim where monetary damages were available, the individual was able to get $20,000 in monetary damages, but also was able to get injunctive relief under both the state and federal law. And so I raised that as a good practice kind of point to think about when you're bringing claims under Title III of the ADA. Because of the limited remedies that are available, you might want to think about whether you're bringing them in a jurisdiction that has some sort of state anti-discrimination law, what the remedies are available, and bring both. So that way you can kind of expand the breadth of damages and remedies that are available. So I think that takes us then to kind of, in these various scenarios, what exactly are kind of examples of reasonable accommodations that an individual with diabetes may or may not need? And I'm going to turn it back over to Dr. Bruggeman to address these.
All right. So things that people with diabetes may need would be permission to bring their supplies in with them. So that was kind of just covered that that was not always guaranteed that people could bring them in, but they need to bring in syringes, lancets, needles, insulin pumps, continuous glucose monitors, and insulin. And sorry about that. It's also important that we consider the security checkpoints in some places and the type of technology used at these security checkpoints. So I think we'll go over this in a case, but some X-ray scanners are not compatible with some of these devices, especially insulin pumps specifically. It can actually break them. And so a reasonable accommodation may also be that we need to have some alternate form of screening for these types of devices. The ability to keep supplies and food nearby. So we just mentioned it's important for people to have access to snacks, drinks, low blood sugar treatments, taking their medication. And that may include, like we mentioned with type 1, you have to have insulin, which has to be injected. And so injectable medications, using a restroom. So some people, may need to have a bathroom break more frequently. A space to rest until blood glucose levels become normal. Like I mentioned, if your blood sugar is high, you're at higher risk for developing dehydration. And so a space to rest may be necessary. Rescheduling an exam if blood sugar levels are too high or low. So I think I mentioned the cognitive effects of both high and low blood sugar, but both of them can have cognitive effects. And so if you have a very high stakes test or something like that, you may need to hold off on taking that. And then assistance with management for children in daycare centers, camps, and recreational programs as well.
So let's take what we've learned and apply it in a couple scenarios. So we've kind of identified 3 of what we think are the most common situations for people with diabetes in places of public accommodations that they're most likely to encounter potential issues with getting the kinds of accommodations to provide equal access. So the first scenario we have here is Michael is trying to go through TSA security to make his flight to Hawaii for a holiday vacation. TSA refuses to let him keep his insulin pump on, saying that he has to remove it and put it through the X-ray machine. Michael asks if he can have a pat down and visual inspection instead. TSA responds that they are short-staffed and can't accommodate these requests. So From the legal's perspective, is the A violated? I will preface this with, I'm sure this is a room full of lawyers and everybody's got their own thoughts, and you get 10 lawyers in a room and you'll get 30 different answers. But I think this is a resounding yes. This is a violation of Title III of the ADA. Particularly here when we're talking about an insulin pump that is connected and is providing. I mean, that is just any sort of attached device to require somebody to remove it. And I think in the context of a continuous glucose monitor, which I use often, but to remove that means it's done and you don't have it. And I don't often bring enough supplies with me in the first place. So I think I would say in this case, this is an absolute yes. And even the argument and the notion that, well, we are short-staffed right now, we're really sorry, we can't accommodate that request. That is an insufficient reason. I mean, there needs to be some way, some staff there's got to be something done that would allow a person to come over and do a separate private pat. And I think this has come up. I personally experienced this, as Dr. Bruggeman just said, when it comes to the full body scanners that are often used. So, when you go through TSA, there's the option often of going through a metal detector versus the full body scanner. And a lot of CGMs can be impacted by the full body scanner. So I always request either to use the metal detector or for a private pat down. I just would, as a personal tip, make sure you give yourself plenty of time to do that through the airport in case you run into these issues. But I think absolutely there would be no question that under this scenario, the Title III of the ADA would be violated.
Yeah, and then just to throw in, I think we mentioned this already, but the insulin pumps actually, like we just had another member of the ADA who was forced to put their insulin pump through an X-ray scanner and it broke it. So, and these are like thousands of dollars pieces of equipment. So you cannot put your insulin pump through an X-ray scanner. It could break the equipment. And if people, so say Michael took off his pump and it somehow messed up his pump site, like the place where the pump actually goes in, that could, if they don't have backup pump site supplies, and like I mentioned, you can't be without insulin for very long with type 1 diabetes. And so it is definitely reasonable to ask to have a pat down and visual inspection. And then like was mentioned, some of the full body scanners, the companies don't guarantee, like CGMs and pumps will survive the full body scanner either. And so, all these things are things that need to be accommodated.
And I'd add, in that scenario, we consider, if you're going to bring a suit under Title III, look, if Michael's forced to take it off and there's pain and suffering that attend that, look to see if there are state law claims that you might be able to bring to get some damages in conjunction with that. So the second scenario that we've got deals with hospitals, medical offices, and long-term care facilities. So Kim has diabetes and needs to be admitted to a psychiatric facility. Her family has contacted a few facilities nearby, which all denied Kim admission, stating that they cannot manage her diabetes. And I want to first ask Dr. Bruggeman her thoughts on this before I delve into the legal perspective, but I'm really interested in her experience and thoughts on this particularly.
Yeah. So when we were creating this talk, I actually asked Anthony, like, is the ADA violated? Because I have definitely experienced these issues. So people who staff psychiatric facilities are, they hardly ever have an endocrinologist on staff or supervising these patients. Often they'll have, a family medicine physician who's involved. But much of the time they don't really have the staff or resources to adequately manage diabetes. And we've had some circumstances where people have not had their diabetes adequately managed in these types of facilities. And so I had one circumstance where a patient with type 1 diabetes was not given mealtime insulin. And that's like kind of one of the mainstays of diabetes management, is you have to cover your carbohydrates, like your sugar, you have to cover it with insulin. But she was only given insulin to correct her blood sugar, and it obviously did not work well. Her blood sugar went up sky high, very, very high, ended up in the emergency room. And really the only issue was that they weren't giving her enough insulin. So this is not like some, abstract scenario that's never going to happen. It's definitely a common thing that we see.
Yeah, and I mean, as all lawyers on this webinar right now will attest to, the common answer we get in law school is, well, it depends, right? It depends. And I think, I was a bit surprised to hear that there are such categorical denials of people with diabetes trying to get into some such treatment programs. But I think when we're talking about the defenses available, fundamental alteration, direct threat kind of comes to mind, right? So, for example, if you are a person who relies on insulin needles and are going into psychiatric facility and may have a constellation of disabilities that could or could not manifest in something that could pose a direct threat to others, that might be a justification, right? Or it depends on what kind of long-term facility you're going into, what is the treatment, the specific treatment you're getting, if that specific treatment has to be done in a certain way, for example, that requires no cell phones to be there, and your request is, well, I'm a person with diabetes and I need to have my cell phone with me at all times. Unless you can maybe do an alternate monitor or something like that, that might be an example of a fundamental alteration where the program isn't required or is excused from following Title III of the ADA in that specific program. But I think the lesson learned here is it's going to depend on what types of disabilities are at play for the individual, what kinds of treatment they need for both, in this scenario, what kind of psychiatric treatment and what kind of treatment for diabetes, and kind of what the facility is offering. So I think, again, this is just kind of it depends, and you have to look at your jurisdiction, look how it's dealt with these issues, and look to see what kind of fact patterns are analogous to yours. So the final scenario, which is my personal favorite, Jalen is excited to attend his first Philadelphia Eagles game. He's packed a bag of snacks and backup supplies in case the CGM or pump stops working during the game. When Jalen gets to the front of security, he's told he needs to store his bag in a locker and that he can't bring outside food in. Jalen tries to explain that he has diabetes, but the guard says either dump the bag or go home. Is the ADA violated? I say 100% absolutely yes. And every time I walk through security at a concert venue with my bag, I like gear up for that fight. I'm ready. And then it's always like, oh, it's totally fine. I'm like, okay, good. But I'm always ready for it. And I think, the US versus SFX case that we talked about earlier is a good example of exactly why that is. I will say, and before I turn it over to Dr. Bruggeman, one thing that I will kind of talk about that has been percolating more recently, I know that in theme parks, some theme parks have more recently kind of changed or modified their ADA policies. And so I know that particularly the Americans with Diabetes Association has fielded a number of inquiries for people with diabetes related to Disney and their disability access service program. And there are some changes to that program within the last few years. And it kind of narrowly defines their disability access service program to individuals with developmental disabilities, but doesn't really mention other disabilities. And so I would just offer for folks who have encountered that or get questions on that, Title III of the ADA still applies. And so while that might be a specific program for a specific group of people with disabilities, it doesn't mean it erases Title III. And so I have attended theme parks in the past. I've had to carry a bag with, snacks, insulin, that sort of thing. And often theme parks require you to put those bags in lockers or storage facilities, and you can't get in line with them. And an accommodation that has typically been made for me is, well, I can just go up, talk to an attendant, and they could say, all right, come back in 30 minutes, and then we'll let you in the exit, and you can, which is great. I fully appreciate that. But if you ever run into a scenario where you're going to a theme park or something like that, I highly recommend contacting the theme park at least 30 days in advance. Reach out to them, call somebody, find out what accommodations they can provide you for your disabilities, particularly for your diabetes. Give it that much time because more often than not, people get the runaround and don't know who to speak to, or they get sent to one person, then to another person. So in kind of navigating all that, again, give yourself time when planning a trip to make those requests and document. Every time you speak to somebody, get an email that you can send them an email confirming that we talked about this, or you promised this. I want to make sure, get that in writing and print it out, take it with you. So if you get to the facility and you get to Disney and you want to go meet Mickey and all of a sudden there are issues, you've got proof that they need to accommodate that. So Dr. Bruggeman, what are your thoughts on this one?
Yeah, for sure. This is really important that he's able to bring in his supplies. We've kind of gone over these things, but you have to be able to monitor your blood sugar and treat it if it goes high or low. You have to have access to insulin. You can't go, just a couple hours for the game without your insulin. Like that's not going to work. So definitely needs all of these supplies.
So I think that takes us to any question. Oh, we've got, yeah, sorry, I forgot that. We have resources available that we've got some links here. Also, you can always feel free, I think, to reach out to either myself or Dr. Bruggeman if you've got questions. I've got some additional resources on some of the cases that we talked about, some of the guidance that I mentioned. Happy to share that if you've got questions or thoughts, and would like to open it up for any questions that folks have.
I have one question so far. Feel free to put your questions in the chat. Oh, all right. So are you aware of any litigation involving diabetes alert dogs?
No,
Anthony?
that's a great question. I have not heard that come up yet. I would be very interested, Brendan, in talking with you offline if you've experienced that. I would imagine that you're going to see some overlaps with providing service animals, that sort of thing. But I think it is even maybe I think a separate category. Again, overlap with service animals, but also given the nature of the animal in this case, I think you might even have a stronger argument to be made that you need access to it. But again, it's always going to come down to whether bringing that diabetic alert dog into a place of public accommodation is going to fundamentally alter or be a direct threat to other individuals, and whether there are other reasonable modifications available. But no, I think that's a very interesting issue to raise, and I've not seen anything yet, but would be very fascinated to see how that pans out.
Great. Another question, kind of also on the fundamental alteration point. Do childcare providers, I know we didn't really touch a ton on childcare in this session, but do childcare providers have a fundamental alteration defense about hiring someone to assist with diabetes management if they have a child with diabetes in their facility?
Yeah, I think again, it's always going to depend. But I think in that situation, I mean, it's not as in the scenario with the restaurant where you're making them kind of change the entire food, or it's not like you're having to change nap time because of this. It really is just providing an accommodation for an individual, and you don't have to necessarily hire somebody else to do that. You can train somebody who already works at the facility on how to administer insulin, for example, or how to monitor insulin. So I think it's a fundamental alteration is always going to come down to the facts of the case, and it's going to be a factual argument on what is the service provided, how would it be impacted, and I think it's ultimately really up to a jury whether or not. But I think it's a lot harder to argue that, particularly when you got schools that often provide these sort of things, that a private facility like a daycare can't similarly do that. And I think that's another reason why, while bringing claims under Title III of the ADA, you can still look to guidance from kind of the other titles, particularly Title II, or even Title I in some instances, where there's kind of overlapping facts where you can say, well, while this isn't directly on point, these are analogous situations where courts have found that it is not a fundamental alteration, and it should be extended to this situation as well.
Great. Another question. If you run into a situation at a private club and can't bring a Title III claim, are there still remedies available like a negligent tort claim or something similar?
It's a great question. Again, I think the first thing I would say, well, maybe look to whatever state laws are available to see if maybe there's a broader definition. None come to mind, but I don't know. There could be. I think it would again it would depend on what the facts of the scenario, right? If you were forcibly removed from a club because you are administering insulin and you are physically harmed by that, you might have a assault claim or a negligent hiring claim or something like that. So it would just kind of really depend on what we're talking, what occurs, how you are injured, and there could potentially be other either state or common law remedies available that maybe Title III wouldn't cover. Those could potentially be out there, but it would really kind of depend on, again, the facts of the situation, what happened, what you were denied, what, whether they would allow you to bring those things in or not, that sort of thing.
Great. I think we have time for one last question. Brittany, this one's for you. Is there anything a person with diabetes could do kind of in advance of, attending a concert or something, like getting a letter from their doctor, something similar, like in working with their doctor to make sure that they're prepared to go into that situation?
Yeah, I always recommend people carry letters. Like usually you won't need it, but I think it carries some weight if you have a letter from your doctor where people may just back down and let you do the thing that they're supposed to let you do anyway. So I'll frequently write like TSA letters for people, even though TSA is supposed to know these things and allow, make accommodations, but I'll spell it out in writing in travel letters for people. So they can just produce that and give it to them. Or for concerts and things like that, I think I have written a letter for a concert to allow people to bring in their supplies and snacks and that kind of thing. So it's something standard that doctors do frequently, and we usually will have a template, available. So it's a good thing to ask for from your doctor just to give you some backup.
Great. And I
Yeah, and
believe we have a
Anthony
template.
was mentioning, like, if you're really worried about it, contacting the facility in advance is always a great idea too. Just so they're ready for you and they're not kind of caught off guard and not knowing how they're gonna respond.
Great. Before we wrap up and I give everyone the last code, just wanted to flag that we have one more Fighting for Fairness session coming up next week. And this will go over all the case law that is diabetes related in 2024. It'll be presented by two of our attorney volunteers. So definitely go ahead and register for that if you aren't already. We also have all of the recordings of our earlier sessions on different issue areas at that same website, so diabetes.org/fightingforfairness. Now I'll give everyone the second code, which is 3225. Put in the chat. And then I will also put the attendance and evaluation form link. You must fill this out if you want CLE, and I'll give everyone a couple minutes to fill it out. Thank you so much to Anthony and Dr. Bruggeman for being a part of our presentation today.
Thanks so much, everybody.
Thanks, everyone.